Martha Koome. I'm the Chief Justice and the President of the Supreme Court of Kenya. When you serve the people, you always ask yourselves, what people are we serving? Which people are accessing justice? The report of a justice needs survey, which was done in 2017, determined it is only 10% of Kenyans with justice needs and legal problems who are able to access justice through the formal court system. And if you have found 90% are not able to come to the formal justice system, then you have to address yourselves to the gaps that exist so that the justice we deliver as the judiciary is people-centered. We are heavy on the vulnerable, the marginalized groups, because truly if you can address the needs of the vulnerable, persons with disability, the aged, the poor, the women and children, I think you'll be dealing with 80% of the problems in a country. Because then you empower them to stand on their own, to know their rights, to organize themselves, and to be bold enough to move on with their lives. And this is why we rolled out the social transformation through access to justice. So we have to look outwardly and say we can never transform the judiciary alone. We must transform the people as well. It's a journey where we all embrace the constitutional imperatives of access to justice without any impediment, expeditious disposal of cases, and this also takes into account the distances people have to travel. One of the greatest pillars is the promotion of the multi-door approach to dispute resolution. The other people-centered aspect of justice is the establishment of specialized courts for vulnerable groups, such as the sexual and gender-based violence courts. The other game changer is the establishment of the small claims courts. So this has led to enhance access to justice for the small and medium enterprises, which are truly the backbone of the Kenyan economy and account for almost 80% of the employment opportunities in the informal sector. When it comes to accessibility of the courts, by limiting the distance traveled by litigants, we have established more courts across the country and our Marshall Plan, trying to have a high court in all the 47 counties and a magistrate's court in the 290 constituencies. The other area is leveraging on technology. This has enabled the residents of very expansive counties to easily file their cases. Another area of concern is reducing the backlog of cases. We've been championing that no case should be at the trial for more than 3 years. We have embraced active case management so that no case remains unattended. We have adopted a no adjournment policy. The other area is the one that is described in the Constitution and our Article 159, alternative justice system. We've also been supporting the Pro Bono Legal Aid Services Scheme, and we've done this to ensure that people can access justice equally, regardless of their socioeconomic background. And they can also get equal protection under the law. The new level of consciousness I would be calling Kenyans to is to embrace fairness and justice. Justice belongs to all of us. It is not the preserve of the judiciary, the lawyers, the judges. It is for all Kenyans to own, to partake, to feel, and to seek.